be talking it over with friends and family who've watched the media. They're told not to, but they are human. They do it.
All right, a judge has gone ahead and dismissed a manslaughter charge.
A judge in New York has dismissed one of two charges against Daniel Penny.
Judge has just dismissed count one, the manslaughter charge against Marine veteran Daniel Penny.
Of this hour, the manslaughter charge in the Daniel Penny New York City subway chokehold trial has now been dismissed.
The judge in the subway chokehold case has dismissed the second-degree manslaughter charge against Daniel Penny.
In just the last hour, a judge has moved to dismiss the top charge in a former Marine subway chokehold trial and is now sending the jury home.
The judge of the Daniel Penny's fatal subway chokehold trial in New York City has been dismissed.
The jury just sent a note to the judge. They are deadlocked on the first count in this case. This is manslaughter in the second degree.
The judge has now dismissed the manslaughter charge against Daniel Penny.
The judge granted a motion by the prosecutors to dismiss the first charge.
The judge in the Daniel Penny trial giving an unprecedented lifeline to Alvin Bragg and the prosecution. He's dismissing the most serious charge of manslaughter in the second degree after the jury was deadlocked on it all day.
Racism is still alive and kicking in America. There's no other way to view this. Everyone has looked at the case, and those among you who say that Daniel Penny is innocent have racism and bias in your heart. If you look at the facts of this case, then you understand that Daniel Penny is guilty. But today, white supremacy got another victory. Today, the KKK, the Klansmen, the evil in America got another victory. They got that top charge dismissed. America shall continue to America and shall continue to place second-class status on black people.
I had a murder case where the defendant did not intentionally kill the victim. He went into an ATM on the Upper West Side and tried to rob an individual. Unfortunately, it was an older individual. He was 86. And in the course of the robbery, he fell to the ground. And as a result, he died. This is, under the law, a felony murder, which is akin to intentional murder. However, when I first got the case, I learned, I took the time to learn about the defendant. And it was a strong case. So it wasn't about who done it. I knew immediately who did it. I could prove it. I could take it to trial that day and win it. But it wasn't about that. It was that the more I learned about the defendant and his life and the circumstances, the kinds of things that Jarrell was talking about, that one should take into account the trauma of that individual, I really felt incredibly sorry for him that he had gotten to that point in his life where he felt like there was no other choice but to commit this robbery.
Yep. I'm Detective McCarthy. I'm Detective Medina. I take care of this is where you're at right now.
Cool.
How you doing today?
I'm doing well. How are you guys?
Okay. Very good. Very good. I'm doing well.
Yeah.
You served in the Marine Corps then?
I did, yes.
I served in the Marine Corps.
Oh, nice. Nice.
Got my little desk before the sun and
There you go. Nice, man.
What you doing? What was your enlistment?
I was in 0351.
I was an 0331.
Oh, cool. You get your weapons platoon. Nice, man.
I was not military, so I don't know what that stuff is.
That's like another language.
3rd Battalion, 6 Marines.
Okay, there you go. 36.
96 to 2000.
Nice,
two med floats. Did my thing, and then I ended up here. Now I got close to 22 years here now, man.
Good pension. I was on there. I forget what stop it was at, but some guy came in. He's like, whipped his jacket off, and he's like, I'm gonna kill everybody. I can go to prison forever. I don't care. I don't do this. At that point, I looked to the person next to me like, hey, just hang on to this phone for me. I had my headphones in and took it off and just kind of like grabbed him from behind because he came in just to because he was acting like a lunatic, like a crazy person. So, and he was rolling around on the floor. Yeah, absolutely.
High.
Something like that.
Yeah.
I mean, that K2 that they're smoking, pushing people in front, like these people are going crazy. So
he seemed off his lit basically.
Look at that on a multi-faceted approach of everything that's wrong with the system that we're facing. One, look at the photo that they used to show the victims. It seemed like it was a young, innocent child who was brutally murdered, and it gave that impression. When you look at the photo that was being used, it wanted to set up in the minds of people that we were dealing with a young, innocent child that, just a Michael Jackson intimidator that, was just brutally assaulted. Then you look at the complete failure of our mental health system, a complete failure from the days of closing psychiatric wards and having those who needed help just turned over into the street. Now, we're on the subway where we're hearing someone talking about hurting people, killing people. You have someone on that subway who was responding, doing what we should have done as a city and a state of having a mental health facility. Those passengers were afraid. I'm hoping that the jury will hear all the facts. Based on all the facts that's laid out, a jury of his peers would make the right decision. And I don't want to prejudge that. I'm just looking at all the facts that are involved here and what we did to get to where we are and what we're seeing. Because that could have easily been a case where you saw 3 innocent people murdered on our street 2 weeks ago.
All right, a judge has gone ahead and dismissed the manslaughter charge in the Daniel Perry trial after the jury was hopelessly deadlocked on the issue, going back and forth on it for the better part of the afternoon. Ultimately, the judge dropping it. But, of course, it's not over. There is one remaining, and that is criminally negligent behavior on the part of Penny during that whole incident. That, of course, is now the beholder, and 12 jurors who clearly couldn't agree on the more serious manslaughter charge. Anyone's guess how they will rule when they come back on this lesser charge.
Well, I live in the East Village in Manhattan, so I take the subway multiple times a day. In this instance, I was coming from school. I got out of class around 2:15, and I took the I was at J Street Metro Tech, took the Uptown F train. At 2nd Avenue, a man came on, stumbled on. He appeared to be on drugs. The doors closed, and he ripped his jacket off and threw it at the people sitting down to my left. I was listening to music at the time, and he was yelling, so I took my headphones out to hear what he was yelling. And the 3 main threats that he repeated over and over was, "I'm going to kill you, I'm prepared to go to jail for life, and I'm willing to die." You know, this was a scary situation. And Mr. Neely came on. He was threatening. I'm 6'2", and he was taller than me. So it was. And there's a common misconception that Marines don't get scared. We're actually taught one of our core values is courage, and courage is not the absence of fear, but how you handle fear. And you know, I was scared for myself, but I looked around. I saw women and children. He was yelling in their faces, saying these threats. I couldn't just sit still. Some people say that I was holding on to Mr. Neely for 15 minutes. This is not true. I mean, between stops is only a couple minutes. So the whole interaction lasted less than 5 minutes. Some people say I was trying to choke him to death, which is also not true. I was trying to restrain him. You can see in the video, there's a clear rise and fall of his chest, indicating that he's breathing. I'm trying to restrain him from him being able to carry out the threats. And then some people say that this is about race, which is absolutely ridiculous. I didn't see a black man threatening passengers. I saw a man threatening passengers, a lot of whom were people of color. A man who helped restrain Mr. Neely was a person of color. And then a few days after the incident, I read in the papers that a woman of color came out and called me a hero. I don't believe that I'm a hero, but she was one of those people that I was trying to protect. We were all scared. Mr. Neely was yelling in these passengers' faces, and they looked terrified. The reason why there was no video at the start of the altercation was because people were too afraid getting away from him. And the videos didn't start until they saw that situation was under control. I knew I had to act, and I acted in a way that would protect the other passengers, protect myself, and protect Mr. Neely. I used this hold to restrain him, and I did this by leaving my hand on top of his head to control his body. You can see in the video there's a clear rise and fall of his chest, indicating that he was still breathing. And I'm calibrating my grip based on the force that he's exerting. And I was trying to keep him on the ground until the police came. I was praying that the police would come and take this situation over. I didn't want to be put in that situation, but I couldn't just sit still and let him carry out these threats.
Michelle is telling me that when the prosecutor read that note, she looked down and she grinned. It was not a grin of happiness. It was a grin of, I cannot believe I'm reading this. I just can't believe it. Well, what she couldn't believe is that the jury is deadlocked on count 1. That is the more serious charge, manslaughter, which faces where Daniel Penny would face a term of up to 15 years in prison. As a result of them not being able to reach a unanimous verdict on the first charge, they are not allowed to move on to the second charge.
In New York, the judge in the subway chokehold case has dismissed the second-degree manslaughter charge against Daniel Penny. The jury was allowed to leave for the day after saying twice it was deadlocked over that count, so jurors will return Monday to deliberate on the criminally negligent homicide charge against Penny. The prosecutors say Jordan Neely died after Penny put him in a chokehold on the train in 2023. He claims he was protecting himself and other subway riders and pleaded not guilty to all charges. CBS News legal contributor Jessica Levinson is back with us now to discuss this update. Jessica, what is the reasoning behind the judge's decision?
Well, this is what the prosecution asked for. They said it's clear that the jury, after asking them to do this twice, cannot come to a decision. And so the prosecution is saying we want to proceed with that lesser included charge, the criminally negligent homicide charge. For people watching at home wondering what's the difference is essentially manslaughter requires a higher level of knowledge, a higher type of state of mind, whereas negligence requires something less, requires something closer to there was an accident, but you can still find somebody criminally culpable. So in this case, what it means is that the prosecution has said, we don't want a full mistrial, which is what the defense wants. We want to proceed and ask the jury, what about criminal negligence, that lower included charge?
Can Penny ever be retried on the manslaughter charge?
I think at this point that depends on exactly what the prosecution said to the judge when they said, we want to dismiss this case. I think there's a difference between can they, which I believe the answer, if they decided to dismiss it, it depends on how they dismissed it, but probably not, versus will they. And I think the answer to that is they likely would not again, based on their willingness to move forward with the criminal negligence. I want to be clear that I think the promise here by the prosecution of we're willing to drop the manslaughter if, judge, you say we can proceed to the criminal negligence case indicates that they're not going to refile on manslaughter.
I think the judge will make the jury deliberate if they continue to be deadlocked on this lesser charge.
However long the judge feels, it's totally in his discretion. The defense will object, but legally the judge can give them sufficient time, maybe read them another Allen charge where they say, we are counting on you. We spent a lot of money and time, please. But they've done that already. I don't think that this judge is respecting the jurors' beliefs, and I also think it reeks of desperation from the prosecution.
If Penny is found guilty on this lesser charge, what kind of sentencing might he face?
Well, the maximum technically is 4 years, but I think the max in any criminal case should be reserved for the worst of the worst. It should be reserved for people who have reoffended. I don't think that he deserves that kind of time. This charge that they're deliberating on would be for somebody who's driving recklessly, they're staring at their phone, they're speeding, it's a willful and wanton disregard of human life, and they wind up killing someone. That's not plausibly analogous to what this guy did in these circumstances.
What conversations do you think Penny's lawyers are having right now?
Well, they're thrilled that the first charge is gone, but they're going, man, I can't believe the judge is sending him back. It almost reeks of coercion. The judge is saying, go back, look at the lesser charge. But we did. So what does this mean? I think it's scary. I've been there. Jake, I've been there where they take 4 days. They're going to take another day. It is agonizing.
It sounds to me like you're suggesting that the judge is basically telling the jury, not in so many words, but suggesting you really should convict him on this lesser charge.
I wouldn't go that far because the judge is doing his job, and I'm not even saying that he's done anything illegal. What I'm saying is that it reeks, the image of what it looks like is, well, wait, you've already deliberated on that lesser charge. The prosecutors dismissed the main charge. So I'm going to send you back there, and I'm going to have you consider that lesser charge again. I'm just saying that there's a fair argument to make from the defense that it almost implies that the judge is suggesting there may be something to this lesser charge. That's all I'm saying.
The judge told the jury to go home and try to think about something else over the weekend, not this case. Is that even possible for a jury?
Absolutely not if you're human and not a robot. Picture a tiger on a unicycle with a Nazi helmet juggling balls. Okay, wait. Forget about that image. Don't think about it. Come on, they're obsessed. They're going to be thinking about it. They'll probably be talking it over.
Yeah, Drew, quite a striking development here on the fourth day of jury deliberations in this trial of Daniel Penny. And it all ended with now the top charge in this case, that being second-degree manslaughter, being dropped. It all began earlier today when the jury on its fourth day of deliberations came back with a note to the judge and the parties indicating that they had reached an impasse on this charge and could not reach a unanimous verdict. What the judge did next is he gave them what's called an Allen charge, which is an instruction to the jury that essentially encourages them to keep trying, to be flexible, to try to reach that unanimous verdict one way or another, but to not give up and settle on them being at an impasse. They then went back to their deliberation room, kept talking. They sent another note asking a technical question about the charge a little later. And then it ended later in the afternoon with yet another note indicating that after all of this, after 4 days, they still could not reach a unanimous decision on this charge. Then the parties started battling over what should happen next and what the appropriate remedy should be. The defense here, Penny's lawyers, argued at this point there needed to be a mistrial and that anything else would be coercing the jury into reaching an unfair decision. They lost that argument. Instead, the judge went with prosecutor's proposal. They proposed dropping this top charge of second-degree manslaughter and instead going to the second and final count, a lesser charge of criminally negligent homicide. So they still have a chance of salvaging this trial and reaching the guilty verdict that they want, but certainly prosecutors here suffering a big loss with getting their top
courthouse,
charge.
right? So yes, the judge has dismissed that first count, the most serious charge, second-degree manslaughter, and he told jurors just moments ago that he said, quote, what that means is you are now free to consider count 2. Whether that makes any difference, I have no idea. And then he sent jurors, now he's sending jurors home for the weekend and telling them they'll come back to deliberate the lesser charge, criminally negligent homicide, on Monday. So the trial is not yet done, but the latest here from the courthouse is that the judge has dismissed the most serious charge, second-degree manslaughter, and now jurors will come back on Monday to deliberate the second charge, criminally negligent homicide. As you were talking about before the break, Martha, there was some back and forth, particularly from the defense, who had some concerns on whether jurors should be allowed to deliberate the lesser charge. Defense attorney Thomas Kenneth telling the judge he thought it might be coercive to jurors. It appears like he's trying to get all of this on record, all of this in the court record to possibly perhaps bring up an appeal in the future. But for now, this trial is not yet done, and Penny's fate is still not decided by the jurors here at the courthouse. So
yes, this was always going to be such a tough case because the issue is, I've never thought this was going to be a manslaughter case. I think I tweeted about it that it was never really a second-degree manslaughter case. It was always a question of whether it's criminal negligent homicide versus an outright acquittal. The thinking being is that Daniel Penny received training specifically on chokeholds that normal people would not, like everyday citizens would not receive. And his own instructor stated that you're only supposed to hold them for about 5 seconds. Daniel Penny held him in a chokehold for about 6 minutes. So I always felt that there was going to be disagreement on the jury, and the fact that the first count was dismissed was probably the right decision. It was never going to be a conviction on that count.
I'm shocked. This is very surprising. Whether you're talking about the dismissal of the top charge from the prosecutor, that's a very rare move and a very big move, because if the prosecutor had not moved to dismiss that charge and it stayed as a hung jury, they would have the opportunity to retry that case later. Dismissing it now means it's gone forever. So it's a very big move by the prosecutor. And then the judge even himself saying, I'm not really sure if this is appropriate or I have the power to do so, but bringing them back for another week, because we're now going to come back on Monday to deliberate on this. There are so many appellate issues and so many even just trial issues that I think Daniel Penny is really doing well for himself, where maybe a day ago he's a little bit more worried. This is, by the jury, a compromise verdict, and the judge themselves said they did not want that. And what I mean by that is it's peculiar to look at a case like this with the facts that you have and say that you are hung on the idea of Daniel Penny being reckless, but you're still considering him being negligent. If you're making a distinction between the two, that means you, to some degree, don't believe it's self-defense. Because if you believed it was self-defense, it would negate both of those charges. So the question becomes, why do you think he was not reckless, but think that he's potentially negligent? It doesn't legally make sense. The only thing that makes sense is they're trying to kind of, for lack of a better term, split the baby and compromise.